that is the insidious nature of these things. It's, there's a tend to focus on the actual award, but really what the risk is, because often the awards costs are not given, but to defend yourself, to go to, in this case, the OMB or potentially into another court or tribunal, and just defend yourself, to say, no, this cost shouldn't be awarded, or this suit shouldn't be won against me. That cost in itself is a punitive penalty. And so when people trying to participate in the Ontario planning system right now, and it's happening, we have lots of reports, one-on-one reports of this happening, where people are going to resist, say, an OMB, planning decision. They're going to the OMB, and they're advised by their lawyers and planners, it's going to cost X thousands of dollars for me to make the case, and if we lose, they may seek costs against you to thousands of dollars more, and that's the chill. So people say, they go home and sit at the kitchen table and talk to their spouse and say, this is what we're going to do. And the spouse says, it's not worth losing our house over. Why would we put ourselves at that financial risk? So instead of the validity of their complaint or their concern is not heard because they are silenced by the fear of economic intimidation. No, I didn't ask either. But I know that the magnitude of previous cost awards in the history of the OMB was something like $15,000, and believe me, the number of lawyers I was called to testify at that particular cost of hearing, and the number of lawyers in the room at that time, you could see that the costs to either side were far exceeding $15,000. It went on for 20 days or something, a very long period of time. Well, there are several cases of this kind appearing from time to time, but more significantly, some of these, it's the larger consequences. We're getting clear indication that people are not participating in public planning discussions for fear of this. That it seems to be that the common advice they're getting now is, many people are getting is, be prepared for an attempt at costs, or be prepared for the potential for, if you become involved, to incur a personal lawsuit because of your participation. So that chilling effect, I'm fully confident, is widespread from direct communications and experiences and information our office received. The number of actual cases, there are several, but it's small, but the chilling effect is large. There was a decision and a change of government in BC and a change of direction there. I guess it'll remain to see if that was a wise decision in the long run. But clearly, Quebec has moved squarely into the legislation along these lines and has seen the need, as has many jurisdictions in the United States. I mean, yes, I'll agree with the minister in this particular major OMB case, the Big Bay Point Award. The OMB wisely, in my opinion, ruled, and specifically cited the chilling effect of this. But nonetheless, it has not stopped that from being a tool. We don't want that tool to become ingrained. I mean, associated with that particular case, there are also private lawsuits involved. So this new practice that is creeping into I don't want it to reside as a common tool in the toolkit of our legal system, so that that the chilling effect extends out, and it undermines not only the public participation in our planning process, but the very essence of the Environmental Bill of Rights. It is, it's important legislation, unique legislation in the world, that is founded on the principle of the public participating in government decision making about the environment. It's a direct threat at the very central tenet of a very, very progressive piece of legislation that I am charged with defending. So I see it as an urgent necessity to quell this. I mean, if it's not legislation, then some other directives or policy tools to make it clear that the intent of our public participation mechanisms in Ontario is to encourage public participation and let the people's voice be heard. And they shouldn't be intimidated or threatened or reserved in that regard. The system now encourages citizens to go before the various tribunals and things. I mean, it's an open system, whether it's the OMB or the Environmental Review Tribunal or the courts for various kinds of lawsuits, including lawsuits launched under the Environmental Bill of Rights. But the problem is the response of the system, people scaring people away from what is now their right to go forward. So how do you do that? Well, you give them degrees of protection. There are a couple of options, leave it to the lawyers to decide, but certainly something as simple as strict rules on the possibility of cost awards in things like the OMB, whereas a strict system where you know in advance that if you have to establish that it's frivolous or vexatious. There's been discussion in some of these models about actually reversing the onus, making the make sure that there's a heavy burden of onus on the person who wants the cost to prove that there was vexatious or frivolous behavior or such things. There's a couple of options, but clearly the intent of any set of rules, whether it be a full piece of legislation or just a change in policy and rules at various tribunals and court directions, is that that people coming in good faith to make their comments in a legitimate matter should have protection from repercussions and reprisals.